Good morning, everybody, and thank you for joining our Let's Talk About Common Law Partner Rights. I'm Catherine. I'm the Community Relations and Engagement Coordinator here at Seniors NL. And before I go ahead and introduce our guest speaker, I would just like to take a few minutes. Sign language interpretation for our Let's Talk About sessions are supported by the Disability Policy Office, Department of Seniors, Youth, and Social Development, to whom we are very grateful. Before I introduce today's presenter, I'd like to cover a few housekeeping tips. Please mute your mic to block out any outside noise. The closed captioning button is on the bottom of your screen. Please put your questions and comments in the chat as we will be monitoring those throughout the call. This session is being recorded. And if you have any presentation requests, please don't hesitate to reach out.
Great.
And Barb, can you please go ahead and read our land acknowledgement?
Good morning. We respectfully acknowledge the land on which we gather as the ancestral homelands of the Beothuk, whose culture has now been erased forever. We also acknowledge the island of Ut'aumguk as the unceded traditional territory of the Beothuk and the Mi'kmaq. And we acknowledge Labrador as the traditional and ancestral homelands of the Innu of Newfoundland and the Inuit of Nunatsiavut and the Inuit of Nunatuavut. We recognize all First Peoples who were here before us, those who live with us now, and the 7 generations to come. As First Peoples have done since time immemorial, we strive to be responsible stewards of the land and to respect the cultures, ceremonies, and traditions of all who call it home. As we open our hearts and minds to the past, we commit ourselves to working in a spirit of truth and reconciliation to make a better future for all.
Thank you so much, Barb.
You're welcome.
At the end of the presentation, we'll also be opening up the mics so you can ask your questions directly to Sara. So now I'd like to introduce Sara. Sara is from the Public Legal Information Association of Newfoundland and Labrador, which we call PLIAN for short. Sara is an Access to Justice coordinator with over 15 years experience as a paralegal and has worked with the private firms, legal aid, the courts, and nonprofit organizations. She has worked with all aspects of law, but has a passion for seniors who need help navigating the legal aspects of aging. When not at work, you'll see her volunteering as a first responder with St. John's Ambulance and knitting while drinking coffee at the same time. So Sara, can you please, I'm going to go ahead and stop sharing and you can go ahead and share your slides, please.
Good morning, everybody.
Perfect. We can see your slides.
You can see it perfect. Great. Awesome. So good morning, everybody. Today we're going to talk about common law relationships in Newfoundland and Labrador. And the first thing that we're going to talk about today is what is PLIAN. We're going to talk a little bit about the law in Newfoundland and Labrador. And then we're going to talk about the differences between common law and married couples. So differences between the two, in particular when it comes to things like family law and when it comes to things like wills and estates. So what is PLIAN? We are the Public Legal Information Association of Newfoundland and Labrador. We are an independent nonprofit organization. We were founded in 1984, so we're coming on to our 40th anniversary. Our whole goal and purpose is to educate Newfoundland and Labradorians about the law and to increase access to justice in Newfoundland and Labrador. What this means is that I get paid to travel all across the province and talk to several service organizations and members of the general public and get them interested and excited in learning about different aspects of the law. We have 2 office locations, one in St. John's and one in Happy Valley Goose Bay. And besides us doing our education services and information services, we also have a legal information line. That legal information line is open Monday to Friday from 8:30 to 4:30, and it's toll free. The numbers are on the screen right now. So we have a toll-free number, 1-888-660-7788 or 709-722-2643. Or if you're in Labrador, you can call 709-896-5235. And if you are tech savvy and prefer to get an email, you can certainly email us as well at info@publiclegalinfo.com or labrador@publiclegalinfo.com. What happens on this legal info line is that you'll call us, you'll get to speak to a person, a human, not a robot. You ask your questions and we'll be able to either answer them for you or we'll be able to give you resources on where you can find the answers or where you can get help as well. As an aside to that, we also offer what's called our lawyer referral service. This is a 30-minute consultation for $40, taxes included. What these lawyers are going to do is they're going to give you some basic legal advice surrounding what it is you're looking for. They're not going to provide any legal work. So that means they can't go to court for you and they can't fill out any legal forms, but they can give you advice surrounding that. This service is provided all across Newfoundland and it's available to people living outside of Newfoundland as well. There's about 45 lawyers involved in this. There's no obligation to hire them. And these lawyers do phone consultations as well. So if you're in a community that doesn't have access to a lawyer, the lawyers on our roster will meet with you over the phone or via Zoom. And I'll touch on two other things that we do offer. One is the Journey Project. It is a joint initiative with PLIAN and Sexual Violence NL. It provides trauma-informed support and general legal information for survivors of intimate partner violence and survivors of sexual violence. Their contact numbers are below, but if you call our main line, you can also get access to the Journey Project as well. We also have our legal rights for newcomers. It provides information support for refugees, immigrants, international students, temporary foreign workers, and anybody else who is new to the province and new to the country. And again, you can contact them through the emails listed below, or you can contact our main line and we can refer you on to our newcomers project. So a lot of people ask me, hey, Sarah, what is the difference between legal info and legal advice? So here's the difference. For me, as an access to justice coordinator, I can provide you with the clear-cut law. So you have to be 17 to make a will, for example. I can provide you with the statutes, laws, and regulations and tell you what they mean. I can also provide you every single possible option that you have in your legal situation. So I can give you, you have option A, B, C, or D. I can also discuss case law and what that case law means. Where the line is crossed is if I tell you how to complete your form. So what that means is that I can tell you where things go in boxes of forms, but I can't tell you the words to put in those boxes. I can't tell you what is your best option. So if I say, you have option A, B, or C, I can't say you need to do option A. Okay, that's legal advice. I can't tell you what to argue in a court of law. I'm not a judge. I can't do that. I'm not Matlock. I cannot tell you what to argue. And I can't provide opinion. So I can't say to you, I think a judge is going to rule this way. So that's the difference between legal info and legal advice. So any questions, comments on what we offer from PLIAN?
There's no questions in the chat with regards to
Perfect.
the few slides. However, we did actually have a very first question that said, will we be able to provide a copy of the PowerPoint afterwards to everybody that joined today?
So unfortunately, I cannot provide copies of my PowerPoints. But if you have any further questions or anything like that, I can certainly answer those.
Okay, and just to remind everybody, the session is being recorded, so you can view this at a later time on our YouTube channel. Everybody that's on the call today will receive the link afterwards.
Okay, so some background information on common law rights. All couples, regardless of sex, gender, have the same legal rights and obligations to each other throughout Canada. The exception is polyamorous. So poly relationships do not have those same rights, and we're not going to get into that here today. The laws of Newfoundland and Labrador, they're based in two separate and distinct jurisdictions. So we have provincial jurisdiction and provincial legislation. So things that surround, for example, our wills and estates, things that surround the Family Law Act, that's all provincially legislated. We also have federal jurisdiction. So things like the Divorce Act is the one that comes to mind for me. So what that means is that each province has their own specific laws. So that means the laws of Newfoundland and Labrador don't necessarily apply in Nova Scotia or British Columbia or anywhere else. So our Wills Act is only for Newfoundland and Labrador. It doesn't affect, Nova Scotia is different. BC is different. Ontario is different. However, federal law applies across the country. So if you're talking about getting a divorce, that is the same all across Canada because it's governed by federal legislation. So some examples, land and home ownership is covered under provincial. Personal property, so the things, tangible things that we own, is covered under provincial. Non-married couple separations, so common law separations, are covered under provincial law, and wills and estates, as I've mentioned before. Your federal laws are things like the federal income tax, Canada pension plans, divorce, employment insurance. So when we're talking about common law relationships, we kind of have to look at two different sets of laws when it comes to common law. So common law couples don't exist in provincial law. So what that means is that if a couple has been together for 1 day or 1 year or, 100 years, they don't lose any rights and they don't gain any rights. So we tend to use the words married and non-married. I'll use common law and non-married interchangeably just to make it easier. So common law is at a federal level and it depends from program to program. So it's not the same all across the board. So each federal program has different standards for what makes a couple common law. So when you're talking about, how do we file our income tax? When do we file our income tax together as a couple if we're not married? That runs under federal programming and federal law. So different laws apply on some, and it depends on if something is either federal or provincial jurisdiction. When it comes to land and home ownership, couples do not gain rights to property based on relationship status unless they get married or unless they specifically have an agreement in writing under the Provincial Family Law Act. What this means is that the Family Law Act states that only married couples, so you've got the ring on the finger, you had the party, you got the piece of paper, you have a 50-50 right to matrimonial property. It's only if you're married. Some couples, however, choose to sign what's called a domestic contract, which will give each other rights in the relationship. So if you are deciding to move in with somebody and you're not getting married, it's best practice to do a domestic contract, which lets you know what you have rights to in that relationship should that relationship dissolve. So your personal property is anything owned by you that's not land. So it can be owned by one person or more. For example, your bank accounts, your cars, furniture could be considered personal property. Anything that's tangible is personal property. So common joint owned personal property are things like cars, bank accounts, and things that you acquire by a couple during the relationship. So appliances maybe, and pets as well are the most common joint owned personal property that we see. So in the eyes of the law, pets are considered property. Okay, so and this gets really tangly when we love our pets and a relationship dissolves, trying to figure out who gets the dog or the cat. So in some cases, a party has been ordered to buy out the value of the cat or the dog or the pet. So the most recent case we have on this is Baker versus Hermina, and it was a Court of Appeal case here in Newfoundland. The traditional approach is whoever bought the dog prevailed. So if I bought the dog, I own the dog because it's my property. Any questions on property so far?
If anybody does have a question at this time before we move on to next slides, I think it would be a good idea to, you can certainly take yourself off mute and ask Sarah the questions as we go by. There is one in the chat saying, is cohabitation agreement the same as domestic contract?
Same thing, yes. Domestic contracts, cohab agreements are the exact same, just a different word.
Okay. So Sarah, I do have a question for
Sure.
talking about the family law when you spoke about the Family Law Act that you could register in there with regards to property. Why would somebody do that? Say, for example, I know we're talking about common law, but why would somebody do that if they're married and go to family law to say they're 50-50? What would be the purpose of that? Because you
I'm not
mentioned
sure.
you mentioned that the act itself only applies for individuals that would be considered married,
Correct.
not right. So why would somebody that's married go to the Family Law Act?
That's the Family Law Act is the act that governs that. So the Family Law Act is the act that specifically states if you are married, you are entitled to 50% of the relationship if the relationship dissolves or if a partner passes away. That's the act that specifically states that.
Okay. Okay. We've got another question here in the chat with regards
Sure.
to the few slides that you just talked about. What if a pet comes from the SPCA? What are the rights then?
It's still considered property. So you would have to decide who is going to take ownership of that property.
Okay.
I don't know what the agreements are in place for the SPCA. If they have specific agreements, that's something you would need to look at. But it's whoever signed the paper. If you both sign the paper, one person is going to have to buy the other person out.
Okay. This person here asked a question, but maybe coming up in the next few slides. I may be ahead of myself, but is property covered in a will? And I believe that would be a yes.
That's coming up.
Property, yeah, matrimonial, land deeds. That will also be covered in the next few slides.
That will be covered, yeah.
Okay, there are no other questions there in the chat.
So the separation, when we talk about separation, it's pretty much identical for non-married and married couples. The big difference between the two is the end result. So if you are separating as a non-married couple, then your separation will be covered under the Provincial Family Law Act. What that would say is that if you are non-married, so you're living common law, what you generally come into the relationship with is what you leave with. Okay, unless you have specific agreements in place. If you have joint ownership of, say, a house, then you would have to figure out how that is split, and usually that's 50-50. If you are separating as a married couple, then both the Provincial Family Law Act, which says doesn't matter who owns the house, whoever the house's name is in, if you are married, it's going to be split 50-50. But also you need to look at the Federal Divorce Act as well. So there's two acts that are in play when it comes to a married couple. So for example, if I have a house that's in my name, my partner moves in with me, that's great, but the house is still in my name. We break up, the Family Law Act would say he doesn't get the house at all. It's not, his name is not on it. If we got married and I own the house was in my name only, we got married and we split up, federal law and family law states because we were married, he gets 50% share in this house. So when we're talking about separation, we want to consider a couple of things. Rights and obligations associated with birth parents are not affected. So when it comes to children, it doesn't matter whether you are common law, not even a partner, or if you are married, those rights are always looked in the best interest of the child. It doesn't matter what the relationship was with both parents. So when we talk about that, we're talking about things like spousal support and parenting plans and child support and parenting plans and parenting time are the things that we're talking about here. So spousal considerations, these are the things that we need to look at. So splitting up property, as I said before, the property is who gets what. Generally, in common law, whatever you come into the relationship with, you leave unless you have your name on, unless you own things jointly. Pension division. If you're a common law, pension may not be, the other person may not be entitled to your pension. Spousal support is always it depends. There's no guarantee for spousal support, whether you're married or common law. It really depends on a lot of different factors that the court will take into account. Things like, was a career sacrificed? Can this person work? Whole bunch of things that the courts look at for spousal support. So spousal support is never a guaranteed. Child support is always guaranteed, is the right of the child, but spousal support or partner support is not necessarily. And that is governed by the federal law. So you would be able to look at that. So couples can agree on, when you separate it, they can agree on what happens with what. You don't have to always go to court when you separate. If you're amicable and you can agree, that's great. You can figure out the property division and the children, that's great. If it's not possible, then you can apply to the courts. So if you are married and divorcing, you can go straight through Supreme Court. If you are non-married, so your common law, you can either go through provincial court for parenting plans and division of property, or Supreme Court. And that just depends on where you live in the province. So here's the big one, and what a lot of people have questions on: relationships and wills and estates. So if you are non-married or you're living common law, you do not have any rights at the provincial level in relation to your partner. So what this means is, for married couples, the Intestate Succession Act says that if a person dies without a will, the spouse will receive a third of the estate at a minimum. What this means is that there's a formula. So if I'm married and my partner my husband dies, I will get 50% of the estate. If I have children, I only get a third of the estate, and the remaining 2/3 of his estate will be split among the surviving children. However, if you are non-married, you get nothing. Okay, you're not entitled to anything, any part of the estate. So Defining spouse, when we're talking about the family home, the Family Law Act defines spouses as two people who are married. Spouses do not include non-married couples. So the family home, or matrimonial property, as it sometimes is called, is the property where the married couple lives together. So the Family Law Act creates a right of joint tenancy for married couples. So what that means is that if one person's owned the property, so I own the house, my husband and I get married, he gets 50-50 share of that home. So it creates a right of survivorship. So what that means is that if I die, his name was not on the deed, and I die, he will get the family home regardless or not of whether there was a will or whether it was named in the will. He will be able to still live in that home. That home will be his. In common law, same thing. So house is mine. I live in it. My common law partner moves in, but his name is not on it. I die. He has no right to that house. So the other thing that people want to talk about too is pensions. They're a unique area of law for couples. So pensions are usually agreements between a person or a bargaining unit and a company that provides the pension. So pension associations, government, unions. They're thought of a contract with certain rules and regulations. So every pension has different terms. So when you are going to split up from either your married spouse or a common law partner, you will need to check to see what the rules are surrounding your pension, because they are different. Just because one pension says one thing doesn't mean another pension is going to say the same thing when it comes to survivors benefits. So when it comes to death or when it comes to splitting up. So you will have to check what the rules are for your pension. So as I said, there's no guarantee that the pension plan will protect a common law partner or how much it will protect them. Normally there are provisions for survivor benefits for spouses, so married, but not necessarily for common law. So you will need to check your pension and the information on your pension for that. So we always show this case here. You know, our Harbor Grace pensioner was left in legal limbo because the same-sex laws in that case was not made retroactive. So they were together for 30 years. They couldn't marry because same-sex marriage wasn't legal, but they were together in a common law relationship for more than 30 years. His partner died in 2012. And the Harbor Grace pensioner, so the pension that he was in, the specific loss to their case wasn't made retroactive, so he was not able to get his partner survivor's benefits or survivor's pension. Unfortunately, he had to sell the house. It was not made retroactive to the retirement date, and that's something that you know, was quite unfortunate for him. But the bottom line is that if they had put in there that he was the common law partner and that he was the beneficiary of that pension, he may have been able to get some sort of benefit. So how do we protect our non-married spouses? How do we protect our common law? So several ways someone can ensure that. So both parties are on the property ownership. So that creates a definite right to the property. So if I have my house and my common law partner moves in with me, I'm going to make sure that I add him to my deed. That way he is a joint tenant and he will be able to have access and he'll have property rights, okay? Things like joint bank accounts as well. So making sure that he is on my joint bank account, that would work. Signing a will. So make sure that if you have a will, you can give a share of the family home or estate to their common law partner. That's very, very flexible. You can be as very specific as you want. You can give them as much as you want or as little as you want when it comes to common law. But if you have a will, you can say, oh, I give my house and my belongings to my common law partner, John Doe. And then the third thing is, as I said before, adding their partner as a beneficiary under your pension programs, your RRSP, and your life insurance. So this takes place outside of the will. What this means is that any beneficiary you name to, your RSPs and life insurances, that's not part of the estate. That's completely separate than your estate because the beneficiary is the one who will get that money. So it's not part of the estate. So you want to add them as beneficiary under your RSP, pension, and life insurance. And then the other thing that we can do to protect our common law spouses is to create a domestic contract. So when you decide that, yeah, I want to be a common law partner with this person and we're going to move in together, we can drop an agreement about what we want our property to look like, what it is that we're going to do, and then what would happen should this contract break up, should this relationship break up. So they're referred to, yes, as cohab agreements or cohabitation agreements. They're agreements that create legal obligation and rights. So married people can also do this as well. They can sign a marriage contract or a prenup. Not really, really common, but it does happen. And domestic contracts can include provisions that exclude rights under the Family Law Act, specifically regarding personal property and land. So what that means is that, say I own my house and my husband and I'm getting married to my husband, and I'm like, you know what, this house has been in my family for years. I don't want you to have access to it. I can certainly sign that out, but I'd have to make some provision for him, monetary provision if something should happen. So they're very, very common, very recommended, especially if you're in common law. You want to make sure that you have a cohabitation agreement or domestic contract drawn up. So, effect of marriage and divorce on wills. If two people get married, any past will that you have is null and void. However, if you are divorced, that will is still in full force and effect. And same with separation. So if you get separated, your will is still in full force and effect. So bottom line is that, and the thing that I always recommend is that when you have a major life change, you should probably get your will updated. You don't want to have your ex getting access to your property, right? So just make sure that if you do get divorced, you will wind up changing your will, but separation doesn't impact wills at all. So if we're separated, he's still entitled to whatever I had in the will. So here are the common misconceptions for common law. Couples living together become common law after 6 months of living together. That is not true. That could be true for, say, federal tax, income tax, and certain things federally, but not provincially, and it doesn't affect anything when you split up. The other common misconception is that common law couples have guaranteed rights to a home based on their relationship. That is not true. We've discussed this. If their name is not on the land, they don't get anything from that land. They don't have a right to that. And then common law couples have a guaranteed right to the estate of their deceased spouse. According to our provincial legislation, they do not. They have no rights at all to the estate of their deceased spouse unless it's specifically stated in the will. So you have to make provision for your common law partner. Any questions?
There is one question in the chat. It says, is that different? Oh, this screen just changed. Sorry, no, that's okay. It just caught my attention there. Is that difference in every province regarding the 6 months of living together? So the 6 months for common law, say you have to be living together 6 months in order to be recognized as common law. Is that different in every province?
I can't speak for every province. I can only speak for Newfoundland.
Okay, can you just repeat that, repeat the law around that again, please?
So that 6 month misconception, that has more to do with, say, federal income tax, like filing jointly is in income tax, having to claim your common law partner's income as your income if you're living together. That's federal law. That's not Newfoundland law. So you may be considered common law federally for income tax, but you're not considered common law for, like, common law doesn't exist in Newfoundland for the purposes of splitting up. So, for example, if I had a common law partner who moved in with me. We were living together for a year. We filed our income tax together. That's great. We're supposed to do that federally. We split up. He doesn't have any access to, my house that my name is on only. Okay. So we're looking at two different pieces of legislation. The federal legislation, which says, yeah, after 6 months, you're supposed to file your income tax as couple. But here in Newfoundland, it means nothing.
Okay. Okay, thank you.
What about can you hear me?
Yes, we can.
Okay. What about in the case of a bankruptcy? If one spouse declares bankruptcy, or is assigned into bankruptcy, the ownership of the other half of the property.
So I really don't know much about bankruptcy, so unfortunately, I don't know the answer to that question. That's something you would have to ask your trustee in bankruptcy and the creditors how that looks. Normally, bankruptcy, your house that you live in is protected. They're not going to throw you out on the street usually. But that's something you'd have to ask them because I'm not familiar with bankruptcy.
Okay.
Thank you. We do have a couple of other questions in the chat, Sarah.
Sure.
We have a comment here, first of all, and then a question. It says, very clear, Sarah, thanks. Could you suggest a few lawyers who specialize in domestic contracts and wills for common law seniors in St. John's metro area?
No.
Okay.
No, I can't recommend specific lawyers. These domestic contracts and wills and estates are very common, and they're a lot of lawyers' bread and butter. So they're quite familiar. Any lawyer in the St. John's metro area is very familiar with wills and estates and domestic contracts. A quick Google search can tell you who would be able to do that. But almost every single law firm I know of does domestic contracts and wills and estates.
Okay. Another question in the chat. Do CPP transfer to common law partner?
I don't know.
Okay.
I don't know. I don't think it does, but I'm not 100% sure. We've gotten several calls from people with issues with CPP when it comes to common law, but I haven't heard the outcome.
Okay. So that's something that we could certainly look into and follow up with everybody on the call.
Absolutely. Yeah, I will do that.
That's the end of the questions right now in the chat.
Could I ask one question?
Absolutely.
Okay. So I'm calling today from sunny, somewhat warmer Spain. My common law partner and I moved here about a year and a half ago from Newfoundland and Labrador, and we had a will in place at that time that sort of looked out for each other and named beneficiaries and so on. But we're in the process now of trying to figure out what happens now. Common law here is a little bit, it's a registered process here, and we're actually trying to go through that. I was admitted into the country under residency under the family visa, I guess, as a common law partner, but we still each independent, let's call it community, equivalent to our provinces, I guess, in Canada, have to register the common law partnership in that community, let's say autonomous community, they call them. So we're in the process of trying to get that arranged and figure all that part about, but we're also then trying to figure out how our wills would be affected in the event of a death. Given that we have no sort of physical assets left in Canada, but certainly financial assets, investments and so on. And so we're trying to figure out how to manage the will situation in that situation to make sure we're captured, we protect each other. And do we have to make changes to our will in Newfoundland or in Canada for that level of protection? Is there anything that you can advise on a situation like ours in this situation?
So I can't, because I don't know international law. So this is where that's going to play in is the differences between the laws in Spain and the laws in Canada. I would suggest that you do speak to a lawyer in either Spain or Canada who's familiar with the international implications. Unfortunately, I really have no clue.
Okay. All right. Thanks.
Really good question.
Mm-hmm.
So Sarah, you stopped sharing your screen, so I know that where you finished your slide. So now actually everybody, the mic is open. If anybody has a question that they want to ask Sarah directly or comment about the presentation, you can certainly place your question in the chat. I'll be happy to read those questions out. While you guys are thinking about that, we did have a few questions that were brought up during registration. So I believe that you've already answered this question, but I'm going to read this out anyway.
Mm-hmm.
So my wife is in a long-term care home. What happens if I die before my wife? Who gets what?
So the question is, I guess the harder question is the person married or not married?
Exactly.
So if you are married with a ring on the finger, according to the Intestate Succession Act, if you don't have a will, according to the Intestate Succession Act, wife would get either 50% if there's no children or a third of the estate if there is children. If you are calling your wife, but she's only common law, then she's not entitled to any of the estate.
Okay. So if that caller is on the line on our sessions, if you'd like to add anything or ask additional questions, please do so. Now, Sarah, I'm going to ask this question, but I'm unsure if you're going to be able to answer this because I think you said at the beginning that you will not be able to address. What are the laws around same-sex marriages if somebody passes away?
Same as in heterosexual marriages.
Okay.
Yep.
Perfect.
As long as you're married, registered marriage with Department of Vital Stats, ring on finger, party, those laws are the same.
Okay, good. Third question that we had that was brought up, it says an online company called Law Depot offers free will kits that you can fill out and have witnessed. Lawyers charge a lot of money for a simple will, so most of my acquaintances don't have one. Is an online will accepted in Newfoundland and Labrador?
It has to be printed off in paper and signed by two people who are not the executor and not the beneficiaries of the estate. So, short answer, that one is fine.
Okay,
Yeah.
Perfect. We have another question.
Just to clarify that was my question, but I've been informed that the will had to be written in the person's own handwriting, holographic will, and it couldn't be printed. Is
That's
that
false? That's false. Yeah, no.
I'm sorry?
That is false. You can print off a will. So
okay. Yeah, so it's a change.
in writing means either handwritten by your own hand or typed and signed. So in order for will to be valid, and this is a bit off topic, but this is what I love is the estate work. Your will has to be dated, has to name an executor, has to be witnessed by two people who are not the executor and not beneficiaries of the will in order for will to be valid here in Newfoundland.
Okay.
What that means is that You don't necessarily have to have a justice of the peace. You don't necessarily have to have a lawyer. As long as your will is dated, witnessed by two people, and signed by you, should be good.
Great. Okay, thank you very much. While I've got the mic, you've mentioned several times ring on finger. Is that just a phrase you use, or is there any legal requirement to have a ring?
No, that's just the phrase I use. You know, the big party, the wedding, where you sign your marriage certificate, right?
No, I'm a marriage commissioner, and a significant percentage of couples that I marry don't exchange rings. So I needed to clarify that.
Yeah, no. You have to have that signed marriage certificate.
Yeah, as long as you have that, you're good.
Yeah.
Okay.
Yeah,
Thank you very much.
Marriage, yeah. Because that goes to the Department of Vital Stats. So that's basically
right.
what I'm saying. Yeah.
Yeah. Thank you.
You're welcome.
Anybody else have any questions for Sara? We do have a few more in the chat.
Sure.
Okay, so I'm going to read this word for word, okay? Regarding children, what rights would your spouse's children have if you meet and they were already reared up and moved on before you met? You got married and you established your matrimonial home and property. After the fact, so the children have grown up, they've moved on, you've met somebody new and then have gotten married. So what rights do those children have?
If there is no will, those children are still entitled to 2/3 of the estate. Okay, the matrimonial home is not considered part of the estate. If you are married and die and there's no will, so for example, if I die, my husband still gets the house, but the rest of the property, 2/3 of that would go to the children.
And if those children play,
it doesn't matter if they're old or reared or not.
Okay, and they were actually children of say your spouses.
Yep. Yep.
In a previous marriage.
Yep. They're still entitled to their parents' estate, part of the parents' estate.
Okay. Perfect. I'm hoping that answers the question that was in the chat for that individual. If it's not, again, I please welcome you to take yourself off mute and ask or additional questions. We have another question here. What is the average cost of a lawyer to do a simple will? For example, if there's no children, there's no and no domestic contract.
The cheapest I've seen here lately is about $300, going up to $900-ish.
Okay.
So you have to call around and ask for the prices because it ranges a lot.
Okay. Thank you. We got another question. So how long is common law considered married, or is it?
They're not.
And then the second part of that is, so common law is entitled to any part of the partner's estate, example, the house, finances, entitlement. So we just have a question about that slide that you went over, just to kind of reiterate that again.
So if you are common law, you are not entitled to any part of the estate if your common law partner dies, okay, unless it's specifically stated in the will. So if you die without a will, your common law partner doesn't get anything. If you want to protect your common law partner, if you want to make sure your common law partner gets part of your estate, you need to make sure that you have a will done providing for your common law partner.
Okay. Thank you so much. There is another question, but that one's actually directed to me. So will the recording be sent out to all attendees who have requested it? The recording itself will be sent out to all attendees who've registered to attend this session. So yes, you'll receive the link. I'm going to say by end of business on Friday, or it could be early Monday morning, depending how long it takes it for it to translate to be posted. So yes, you will get the link to the recording. Another question, can Justice of Peace sign personally It says personally done wills. So can a justice of peace sign a will
As a witness?
as a
Sure, why
witness?
not? They don't have to, but they can. So your requirements for your witnesses of the wills is that they have to be over the age of 19. They're not allowed to be the executor, and they're not allowed to have any benefit from the will. So they're not allowed to get anything from your will. That's the only requirement for the witnesses here in Newfoundland and Labrador. So that can be anybody.
Okay, perfect. That's the last. Oh, we have another question in there. It says average cost of domestic contract. And can I prepare my own in the manner you outlined for wills?
You can. I don't know the average cost. You can. However, where there are two different pieces of legislation for those domestic contracts, I strongly suggest you do get some sort of legal advice just to make sure that you're in line with the legislation when it comes to domestic contracts.
Okay. Another question, is a holographic will valid in Newfoundland and Labrador?
So holographic, meaning that it's a handwritten will. Yes, they are. Good practice to still get it witnessed, though. They don't
Okay.
have to be witnessed if they're fully handwritten, but good practice to get them witnessed.
And I'm going to add the second question, or actually add to that. What about a videotaped will?
Not valid here in Newfoundland and Labrador. So videotaped audio wills, video wills, not valid here in this province. So when we say holographic, that means it's a handwritten by the person who wrote it. Okay. But the practice is, like, best practice is to still get those witnessed. And I have seen tons of them coming into the courts, and they're properly witnessed by two people who are over the age of 19 who are not beneficiaries and not executors.
Perfect. And actually, by the sound of a lot of the questions coming in, we have a lot of questions around wills. So, Sarah, I think,
So
you
I
know,
think we're going to do a will session.
I think we're going to have to do a will session, is exactly what I was thinking. And we'll focus for everybody that's on the call. We'll actually just specifically focus on wills, and that's what our session will be about. So, stay tuned. So, Sarah, we're going to have to work on that. Um, Anybody have any other questions or comments that they would like to ask? There's no more questions in the chat, and I don't have any other questions that were asked during registration. Okay, so I'm just going to move along. And by all means, if somebody has a question before we end the session, the mics are still open. Please go right ahead.
Right. And you have our contact information as well. So you can always send us an email or give us a call. We love talking to people.
Absolutely. And if you're not sure what that number or the email is, you always can reach out to Seniors NL. We'll be happy to provide you with the information, the contact information you need. So just a reminder that as on our next Zoom session is going to be November the 15th. We're going to be talking about tax credits you may not know about. And then on November the 29th, we're going to be talking about mental wellness as we age. So please stay tuned for those meeting invitations. Oh, we have another question in the chat. It says, would an established property in a will change your will? Let me read that first sentence again. Would an established property in a will change your will? So then then the question is, if you allowed somebody to put a temporary, say, garage on your property after your will, would this change the protections under that will?
I'm not sure I understand the question.
Yeah, so the person that actually asked that question, do you feel comfortable coming off of mute and asking that so Sarah can have a conversation and learn a little bit more? Okay, so we'll leave and see if that person will come off mute. Another question. Somebody asked, does a holographic will need to be witnessed?
It
Oh,
doesn't need
yes.
to be, but it should be.
The mute button is on the bottom of your screen towards the left-hand side.
Hi, can you hear me?
Yes,
Yeah.
we can.
Okay, hi. Good morning, everyone. Josephine Johnson here. I am a social worker with the Department of Children, Seniors and Social Development. And yeah, I do have a lot of questions that come at me as a social worker when I'm helping clients in receipt of income support. So some of my questions could be specific to or general. So yeah, my question is if a married couple does have a will and they decide after the fact to allow, say, one of the children to put a temporary structure on the property, but they know it's just there temporarily and it's just a verbal agreement, not on paper. Does that affect the protection of your wills? For example, if you got a husband and wife, you have no children together, you get married, you have your will, you have your deeds, but after the fact, you decide to let your husband's children who they had before they met you build a temporary structure on the garage, for example, on your property. Would that protect your will? And I don't know if I'm being clear on my question, but I'm trying to be as specific as I can.
I still don't really understand the question, but
okay, basically you got a
if
will.
if I have a piece of property,
yes,
and it is willed to, say, I don't know, that property is willed to John. Okay, that property is willed to John. My kids come in and put a temporary garage on that property. Well, when I die, that property is still going to John unless I change my will.
Okay, you've answered my question.
Okay.
Yeah.
Okay.
Perfect. That was that.
And what John wants to do with that property afterwards, that's totally
fair. So you are protected. Okay, great. And that's what I understood, but I just want to make sure. And another, my earlier question, if I could, I don't know if I was even clear, or my earlier question, I think that was pertaining to that as well. Like if you met someone and they had children, but their children were grown up and gone way before you ever met them. And that was my question. And then you marry and again, you have your own deeds and your wills. Yep. Where, like, what rights would they have if you had no children together, but he had children, say, that was grown up and gone way before you ever know who he was?
So the will,
and then you end up marrying that person with children.
Yeah, the will supersedes a family law. So whatever you have in your will, usually that would be protected. So, but if you don't have a will, so this is where the issue is. If there's no will,
yep, you've
then they would be
again.
entitled to 2/3 of the estate. Now, the estate is not anything owned jointly. It's whatever is not owned jointly.
Okay, so anything owned jointly, they wouldn't have that same right. That's unless they were your biological children.
That's right, yeah.
Perfect. Thank you. You've answered my question. Okay, thank you.
Okay.
And sometimes it's nice to ask as opposed to typing, because as you're typing, you're trying to think of how, so the other person understands what it is you're trying to ask, right?
Sometimes it's easier just to have that conversation.
Yes. One more question I had. I know myself and my colleague, we used to do a lot of the domestic contracts with our clients. Of course, now we refer them, of course, to family justice services. That was part of our dual mandate. You might be familiar with Sara here in the Cabinet office with CSSD, income support clients, before policy change, whereby if they apply for income support, they were mandated by legislation to apply for child support and or spousal support. Of course, they're no longer mandated to apply for child support, but they are mandated to apply for spousal support. So, of course, when clients used to come in and we help do up a domestic contract with respect to, and more particularly, parenting together, living apart, we now send them to St. John's to Family Justice Services. So with the domestic contracts, are they still recognized, or like are they still recognized with provincial legislation as much as they were years ago?
Domestic contracts?
Yes.
Yeah, they still are, yeah.
Okay, fair enough, yeah. Because I'm not hearing a whole lot about them, and I know a lot of social workers use them, but then a lot of other social workers would refer a client. And my education with clients was from my own learning and doing courses as this one, which I do thank you, it's very informative, is that with domestic contracts, and I'll always say this to my clients, this works wonderful. And you may have crossed it in your presentation this morning, when everybody's getting along. However, when things change and the relationship is not as amicable, when you are parenting together and living apart, of course, I used to run those sessions as well here in the Carbonear region, then that's where I would encourage them to have the domestic contract registered with the provincial court, and of course also with support enforcement as well.
That's right. So domestic contracts are essentially an agreement. Once you file any like a domestic contract or separation agreement with the court, then it becomes enforceable.
Yes,
So
exactly.
the courts can enforce it.
Yes.
And you can change that at any time. You can file like variation orders, that type of thing.
Yeah,
but that's a whole other presentation
yes,
when it comes to
absolutely. Yes. And I do thank you for touching
and those
base.
types sort of things. But
yeah, absolutely. Yeah. Absolutely. Thank you so much. You guys are awesome. And hi, Kathy. Nice to see your face for a long time.
Nice to see you on the call, Josie.
Yes, nice to see you too, darling.
Anybody have any other questions, comments? So myself and Sarah actually have a lot of takeaways from today's session for other future sessions. So thank you so much, everybody, for all those questions and ideas coming through. I would like to give before we clue up, anybody have any other questions for Sarah?
This is so informative.
Thank you so much, Marjorie. Okay, so I would like to thank Sarah for taking the time today to have this conversation, and we will be having Sarah back again for other conversations, other Zoom meetings. So again, I would strongly recommend and suggest that if you do have a topic that you would like to talk about or even have a Zoom session such as this, please reach out, let us know. The sessions are here on the screen, the upcoming sessions. I do need to stress on the call that next week's session, I failed to say this, will not be recorded. This is a live session only, okay? Because things change so often with different policies and programs, we cannot record that session. If you have any questions or concerns, or if there's information that you're looking for, please don't hesitate to reach out to Seniors NL. This is what we're here for. And again, before we clue up for today, anybody have any other questions for myself or Sarah? And I'd like to say thank you, everybody, for the lovely comments in the chat. Thank you so much. Okay, seems like it's no other questions there. Well, thank you, everybody, for today's session. Please stay tuned for future sessions. Thanks so much. Have a great day. Bye.